Hello, everybody. Welcome to iExamBee's LegalBee. This is Amrita, your law faculty here at iExamBee. In this video today, I'm going to continue with my series for 300 most important questions which are relevant for SEBI Grade A Legal Officer exam preparation. But before we start with the discussion, don't forget to subscribe to our YouTube channel LegalBee and stay tuned with us for all such kind of beneficial videos. If you have any queries, you can reach out to us by writing us an email on hello@iexambee.com. Call us on this number 920-552-4028. Visit our website www.iexambee.com and check out our online courses. Prepare 50% faster with us at iExamBee and download our app from the Google Play Store. 300 most important MCQs for SEBI Grade A Legal Officer exam. This is the 14th part or the 14th video of this series. If you have missed the earlier series, then do check it out in the playlist of LegalBee. In today's video, I'm going to discuss questions from the Law of Torts. First question. Tort is statutorily defined under Limitation Act, Civil Procedure Code, tort law, not defined statutorily, none of the above. So, law of tort is a common law, but what about the definition of this? And statutorily defined means it is defined under a statute, right? So, the correct answer over here is A. It is definitely defined. बहुत से लोग सोच सकते हैं that it is not defined statutorily, but that is wrong. It is covered under Limitation Act, Section 2, Clause M. Just as the criminal law consists of a body of rules establishing specific offense, so the law of torts consists of a body of rules establishing specific injuries. Neither in one case nor in the other, there is any general principle of liability. This statement defining law of torts was made by whom? Salmon, Winfield, Dr. Jenks, Holland, Jennings. So who has made this particular statement about tort law? Correct answer is A. Salmon. Salmon's stance on the whole idea on this particular law was clear when he chose the second alternative, that is law of torts. Remember, this pigeonhole theory of Salmon is very, very important. Salmon and Winfield and their comments, their statements, their theories about law of torts and tort law is very important. The idea of law of tort was taken up by Winfield, Salmon, Woodridge, Pollock, A and D. That is Winfield and Pollock. Correct answer is E only, Winfield and Pollock. They have taken up the idea of law of tort, whereas torts was said by whom? Salmon. Ashby versus White, 1703. This case brings light on which maxim? Damnum sine injuria, injuria sine damnum, ubi jus ibi remedium, both A and B, none of the above. So Ashby versus White case is a very landmark one, everybody knows that, but it is based upon which maxim? Injuria sine damnum. Injury without damage is punishable. Injury without damage is actionable. We can get compensation for injuries which are legal injuries if there is a damage caused. If there is no damage caused but there is a violation of legal right, and this is what Ashby versus White case talks about. It's a leading case on the point where the candidate for whom the vote was tendered basically was elected and no loss was actually suffered by the rejection of the plaintiff's vote. He was not able to cast his vote. There was no actual damage, but still this maxim is applicable over here because there is a violation of a legal right. So there is a legal injury caused. What is the meaning of novus actus interveniens? Intervening act, new intervening act, nicely intervening act, persistently intervening act, wrongful act. Novus actus interveniens or nova actus interveniens means what? New intervening act. Answer is B. This should be an independent act, but remember that. Absolute liability was established in India in the case of MC Mehta versus Union of India Bhopal gas leak case, MC Mehta versus Union of India Taj trapezium case, Rellens versus Fletcher case, A and C both, A and B both. Absolute liability, strict liability, very, very important topics from law of torts. When they were established, what is the difference between both, and the landmark cases related to it, very important. Here the correct answer is Bhopal gas leak case, MC Mehta versus Union of India. Leland versus Fletcher is also important as it talks about strict liability. Which of the following is not a rule under absolute liability? Do not have any exception, very wide scope, cover not only public negligence or fault but cover even personal injuries caused due to the negligence of neighbor, cover not only the occupier of land but also non-occupier of the land. None of the above. So what is not a rule under absolute liability? Correct answer is E, none of the above. That means all these options A, B, C, D are covered under absolute liability. Vicarious liability follows the doctrine of respondent is supreme, respondeat superior. In the course of employment, vicarious respondeat, all of the above. So vicarious liability follows the doctrine of, correct answer is B, respondeat superior. These are the exact words for it. Vicarious liability follows this doctrine. What is the meaning of that? Responsibility of a superior for the act of its subordinate. One of the most common forms is the imposition of liability on the employer for the acts of his or her employee. Master is liable for the acts of his or her servant. Res ipsa loquitur. Very common principle this is. What does this mean? Things speak for themselves. Things inherently dangerous are punishable. By the way, saying a thing can have many inferences. New intervening act. So what is the meaning of res ipsa loquitur? Correct answer is A. Things speak for themselves. Latin term res ipsa loquitur means the things speak for itself. So if there is a situation, particular act is enough to get the idea that what was happened. It is the principle that the mere occurrence of some types of accident is sufficient to imply negligence. Negligence related है ये principle. Which of the following articles of Indian Constitution deal with the tortious liability of administration? 200, 328, 331, 300, 300A. Correct answer is D, 300 of the Indian Constitution. It deals with the tortious liability. Government of India may sue or be sued by the name of Union of India, and the government of state may sue or be sued by the name of state any, may subject to any provision which may be made by act of parliament or of legislature of such state, enacted by virtue of powers conferred by this constitution, sue or be sued in relation to their respective affairs in the like cases as the Dominion of India and corresponding provinces. The states might have sued or been sued if the constitution had not been enacted. So Article 300 talks about sue and be sued. So the administration and its liability for being sued is covered under Article 300. In which of the following cases it was held that government shall be liable for actions done by its servants while doing non-sovereign functions, but it won't be liable for injuries caused while pursuing sovereign functions? P&O Steam Navigation Company, Kasturilal versus State of UP, both A and B, Bhim Singh versus State of Jammu and Kashmir, C and D. Which of the following is the correct answer? A. P&O Steam Navigation Company talks about it. In this case, what had happened, you can see the facts also. The iron funnel that was being carried by workmen. Kafi purana case hai ye, and this was also an important one. First case after independence in India that was dealing with doctrine of sovereign immunity. Remember, when you are studying law of torts, you have to study these very landmark cases, and you can expect questions because ये एक्ट पूरी तरीके से उसी पे डिपेंडेंट है, कॉमन लॉ. Now after independence, which was the following case? Correct answer is very easy, State of Rajasthan versus Vidyavati. This facts also you can read, and here also very important points relating to vicarious liability, doctrine of sovereign immunity were covered. In the case of Kasturilal versus State of UP, court has applied which doctrine? Sovereign immunity, vicarious liability, both A and B, doctrine of strict liability, doctrine of absolute liability. Kasturilal versus State of UP, correct answer is A, doctrine of sovereign immunity was applied over here. The police officials, They were exercising sovereign functions, so they got the benefit of sovereign immunity over here. Contributory negligence is an author of negligence, a defense to negligence, an essential of negligence, opposite to res ipsa loquitur principle, variation of negligence. Contributory negligence is a defense to negligence. What is this? A tort or a wrongful action when it is committed by negligence on the part of both plaintiff as well as defendant. At that time, the defendant can raise the plea of contributory negligence as a defense over here. Following are the facts of which case under law of torts. Now here facts are given to you. Defendant had a series of artificial lakes on his land, in the construction or maintenance of which there has been no negligence. Owing to an exceptional heavy rain, some of the reservoirs burst and carried away 4 country bridges. It was held that defendant was not liable as the water escaped by the act of God. Nichols versus Marshland, P&O Steam Navigation Company, Brown versus Kendall, Holmes versus Mather, none of the above. किस केस के फैक्ट्स हैं ये? आर्टिफिशियल लेक्स देखकर ही हम लोग समझ जाते हैं इट इज निकोल्स वर्सेस मार्शलैंड, वेरी लैंडमार्क केस टॉकिंग अबाउट विस मेजर, दैट इज एक्ट ऑफ गॉड. It was held that the defendant was not liable as the water had escaped by the act of God and not due to negligence. Plaintiff has to show that the damage caused is dash of the defendant's negligence. Consequence, result of, remote consequence, not a too remote consequence, both A and C, that is consequence and remote consequence. Plaintiff has to show that the damage caused is not too remote consequence. If it is too remote consequence, means then definitely the liability of the defendant will not be there. The novus actus interveniens is there. If suppose there is new intervening factor, then there is a break in the liability over there, or it is very less. So always plaintiff has to show that it is not too remote consequence. Defendant shall be held liable if the type of damage is unforeseeable, foreseeable, reasonably foreseeable, remote, intended. When will he be held liable? Logically you have to think, if the type of damage is reasonably foreseeable, only then he will be held liable. If it is unforeseeable, then he will get the benefit of negligence, he will get the benefit of act of God and all such defenses he can take. If it is an unforeseeable act. If it is reasonably foreseeable by a prudent man, then definitely he will be held liable. Which of the following are elements to constitute the tort of defamation? Defamatory statement should be made. Statement must be published. Statement should directly refer to the person who is claiming the defamation that is made. Statement should be false. All of the above. What they have asked you over here, which of the following are elements to constitute the tort of defamation? Defamation is covered under tort law also and also under criminal law, remember that. This is civil defamation that we are covering over here. Correct answer over here is E. All of these are the essential elements for tort of defamation. All these 5 elements. Statement should be made. It should directly refer to the person who is claiming that defamation has been made by him. Directly it should be talking about him. It should be defamatory in nature. It should be false. It should not be the imputation of truth. And it must be published. Which of the following are examples of trespass to person? Assault, battery, false imprisonment. A and B both, assault and battery. A, B and C. All of the above are examples of trespass to person. Correct answer is E only. All of these are actually examples of trespass to person. Trespass to person, trespass to land, trespass to goods. ये 3 types of trespass होते हैं. This is all talking about trespass to person. Which of the following are judicial remedies under law of torts? Damages, injunction, specific performance, re-entry, A, B and C. So they are now asking you the judicial remedies under law of torts, means which are claimable under the court. There are many remedies under law of torts, out of which the judicial remedies are A, B and C only. री-एंट्री इज एन एक्स्ट्रा जुडिशियल रेमेडी, रिमेंबर दैट. इसमें से सबसे ज़्यादा इंपॉर्टेंट है डैमेजेस. आई वुड सजेस्ट ऑल ऑफ यू टू स्टडी द काइंड्स ऑफ damages as well. It's an important topic under Law of Torts. I hope all of these questions have helped you a lot. Download the PPTs and keep it with you for your reference. In case of any queries, you can reach out to us by any of the following methods. Prepare 50% faster with us at iExamBee. Download our app from the Google Play Store. Check out the full course access available on our app as well, even in the offline mode. Thank you everybody. Have a good day.